Hello, and welcome to part 3 of the Riverside Superior Court workshop series on how to prepare for a mandatory settlement conference or trial readiness conference. This is presented by the Riverside Superior Court Self-Help Services, and my name is Patty Rich. Before we begin, please read the following disclosure. This disclosure states that although all of our staff members are either paralegals or attorneys, we are unable to provide you with any legal advice as we are not your attorney. If you need personalized advice or strategy in your case, we suggest that you retain the services of an independent attorney. Now, in preparing for your mandatory settlement conference or trial readiness conference, it's necessary to prepare certain declarations that will provide information to either the judge or the individual who's helping you with your settlement in identifying the issues in your case and the positions parties. Now, for a mandatory settlement conference, the mandatory settlement conference brief will identify these issues so that you know what the other party wants and they know what you want. So it helps you prepare your mindset for the settlement. When preparing the trial brief, however, this will allow you to identify the issues in your case so that you can identify what you need to prove, and you can then analyze how you intend to prove it. Through this document, you'll identify each issue and then what type of evidence, whether it's written or a witness, you will need to present at the time of the trial to prove your position in the case. Now, the spousal support declaration is necessary if there is any issue relative to spousal support in your case. The only reason you would not be doing it is if you already have a spousal support order that you want to keep, or the parties are willing to waive, terminate, or reserve spousal support. The spousal support declaration examines the 14 separate statutory factors that the court must consider when making a spousal support order. So it's important that you have that prepared so the judge has that information. Again, for purposes of trial, this will allow you to identify the issues in the case so that you can identify what evidence you're going to need to present on each of those issues. The settlement conference declaration or trial brief is in the online packet available on our website at riverside.courts.ca.gov/FL-packets. You will look for the packet entitled Settlement Conference, MSC Brief, Trial Brief. It will look just like this. The first page will indicate preparing instructions for preparing for the mandatory settlement conference. And the second page is our intake page. With this intake page, everything put into the first page gets self-populated throughout the remainder of the document, so that you don't have to do a lot of repetitious typing in preparing your documents. It also provides a way of not missing important information that would otherwise get your paperwork kicked out by the judge. Once you fill out this first page, you'll note that everything that you put on the first page is now self-populated. We have our captions, and as you saw before, we have the top page headers as well, and your signature lines will be done. So these packets make completing your forms much easier, and we do highly suggest that you utilize these self-populating packets. If you don't wish to do so, you can always find the forms online by Google searching the form number RI-FL014, and that will get you to the settlement conference statement or trial brief. The first page of the settlement conference statement or trial brief is statistical information. This is to just get a general overview of where you are in your case. The date of marriage, date of separation, and date of service will all be self-populated in our packet. Before you begin the statistical information, though, please make sure you check the box for either settlement conference or trial brief, one or the other, depending on the hearing you're preparing for. At letter D, the court is asking if status has been terminated in your case. If you don't know what that means, it probably has not been done. You would have had to bring a request for order to terminate status and bifurcate. That means you're already divorced and you're only going to trial on all the other issues in your case. If status has been taken, check the box for yes and provide us with the date that you became a divorced person. Otherwise, just check the box no. Letter E is asking if the Department of Child Support Services is involved in your case. Again, just check the box yes or no. They could either have their own independent case or they could be involved in your specific case collecting support. If they have their own individual case, please provide the court with the case number, because we're going to want to try and consolidate the Department of Child Support Services case into your divorce or legal separation case. Consolidation is similar to when you have two trains on two tracks. The trains are independent of each other, and in order to do anything similar in each train, you have to go independently into that train. So you would have a divorce train where custody visitation is dealt with, and you would have a child support train where you would have to deal with child support. Consolidation basically couples those trains, so they're on the same track and they follow each other. Then all you have to do is go into one case to take care of all the issues in your case. F through I provide some statistics regarding the parties, their age, employment, and what their gross monthly income is. This is for purposes of child support and spousal support. J is talking about new spouse income if you've already had status taken, or cohabitee gross monthly income. If you have minor children, their names and dates of birth will already be put into the form. You will need to include their age, their gender, and who the child lives with 51% of the time or more. If there is a joint physical custody where it's a 50-50, if the court has made a determination of a primary physical custodian for purposes of schooling, please identify that individual. Number 2 are the disclosure documents. The court is seeking information on who has completed the necessary disclosures. And in order to move forward with either the MSC or the trial, the preliminary disclosures must be done. The final disclosures are what we are talking about during this video series, and it allows you to prepare for the hearings. While not absolutely required, they are fundamentally required, because without them, you do not know how to proceed, and the court cannot assist you in proceeding. The way to fill this out is, if you are the petitioner in the case, you're going to identify, have you done your preliminary and your final disclosures, your listings? And it would be either the schedule of assets and debts or the property declarations. Then you're going to identify when you completed your last income and expense declaration. Well, if you're the petitioner in the case, you're completing it now. So you would use the date that you are completing your forms at this time. Then, if you're the petitioner, you're identifying what documents have you received from the respondent. Did you get a schedule of assets and debts or property declaration? Did you get a second set? That would be preliminary and final. And also, when was the last income and expense declaration that you saw of the respondents? Now, of course, if you're a respondent, you're doing it just the opposite. You're going to identify what you have done, preliminary and final, and when you did your last income and expense declaration, and you're going to identify what you have received from the petitioner. The next page, number 3, is dealing with existing court orders. Now, the only thing that's really enforceable is a court order. So even if you have an agreement outside of court, it's not really relevant to the issues in our case at this time. So what you'll want to do is only identify what the last order was in your case. These deal with issues of child custody and visitation, child support, spousal support, and then other issues for which you may have orders. You're going to identify the last date of the order and whether you accept those orders or not. This lets the other party and the court know, are we going to be dealing with this issue at the hearing? So for each of these, A through D, indicate if you have an order on those issues, whether you accept that order or not. If there are no orders on these specific issues, then just leave this section blank. Number 4 deals with the settled and disputed issues in your case. This is broken down into the various aspects that may be involved in your case, including custody and visitation, child support, property issues, both community and separate. And the property issues, as you can see, are broken down into categories that are generally seen in the settlement conference and trial arenas. Then we have our community debts, which is usually credit cards, and then anything else. And finally, the separate property is here. The last issue that may be dealt with is spousal support. So these are the various issues that will be addressed in this trial brief or settlement conference declaration. How you fill out this form is going to be different for if you are completing a settlement conference versus a trial. At a settlement conference, you're not restricted to the rules. You don't have to have an even distribution of the assets and debts because you can divide the assets and debts any way you want. You can agree to whatever spousal support terms you want or child support terms you want. In a trial, you have restrictions that are provided by the law, and you need to address those restrictions when you discuss the various issues on this document. So for instance, the first issue is custody and visitation. You're going to identify, do the parties have an agreement, yes or no? If you have an agreement, what is the agreement? If you don't have an agreement, what is it that you want? In a settlement, you just blandly say what you want. So let's say we don't have an agreement, and I'm going to say, like to modify the existing orders such that the midweek visits are eliminated. You're just telling the other party in the court what you want, because that's all that's required at a settlement conference. At a trial, however, you need to explain why what you want is in the best interest of the child. So you would have to go on further to say why you want to eliminate these midweek visits. So the purpose of the settlement conference declaration is to let the other party in the court know, this is what I want. This is what I'm willing to take to avoid going to trial. The trial brief is identifying what you want and why what you want is legally appropriate. So it's going to take a lot more work to do a trial brief, and you may have to do some legal research on the issues in your case so that you can set forth the law appropriate to the issue within your discussion of that issue. As an example here, I would say, I would like to modify the existing order such the midweek visits are eliminated. The midweek visits So I've written the midweek visit interrupts the children's schedule as the other party does not make sure homework is done or the children are returned on time to go to bed on schedule. This disruption has the children falling behind on their homework and makes them irritable the day following the visit. So you're showing why it's in the best interest of the children to eliminate that midweek visitation. This is necessary for trial. It's necessary in your trial brief because it's now identifying the issue. You will now have to look at what you're saying. It's disruptive to the children because they're falling behind on their homework and it makes them irritable the following day. What are you going to use to prove that? Well, you can use your own testimony, but you may also want to bring in records from the school to show that they don't turn in homework the day following the midweek visitation, or that they're late for school generally following the midweek visitation. So your brief for trial is identifying the issues in such a manner that you can then look to say, what do I need to prove these issues? And that's for each of the issues that are identified here. Under child support, you're going to identify, do you have an agreement? And if not, what do you want? For settlement conference, you can just say, I'd like to have child support reevaluated based upon the new timeshare and parties' incomes. But for the trial, you're going to want to be more specific. Child support should be reevaluated because the timeshares have changed in the last custody and visitation order. The other party's timeshare was reduced to 20% from 35%. Furthermore, the other party has received a raise. My hours have been cut. I got a promotion, whatever the case may be. Once you've identified those facts, you can then look at those facts to see, what do I need to prove this? Do you need to present the income and expense declaration and the pay stubs associated therewith that the other party has provided to show the raise? Do you want to reference the last custody and visitation order to show the reduced timeshare? Again, these forms are there to help you prepare for your trial or to make the other parties aware of what it is you're actually seeking for the settlement conference. The division of community property is broken down into your residence, your home, what is it you want to do, your cars, your retirements. money investments, business and self-employment, and any other assets. Now, at the time of a settlement conference, you can propose anything. It doesn't have to be equal. Look at what it is that's important to you, and then set forth what you want based on that. You may feel that your retirement is the most important thing to you, so you're willing to give up a lot or take on the debt so that you can keep on your retirement. It may not end up in an equal division, but that's what you want. And the other party can agree to it because they may not want to be tethered with all the debt that you guys have. So they're willing to let you keep your retirement if you take on all the debt. Every person has their own priority, and you need to focus on that priority. Now, for purposes of your trial, though, at this point, you're going to have an even distribution of the assets and debts, and you're going to have to explain how what you're proposing will result in that even distribution. So, for instance, you may indicate under residence that you are proposing that you get to keep the home, which currently has X amount of equity in it. However, in order to sell the house at market value, you would need to put in X amount of repairs. So that should be deducted from the net equity. And in return, you're willing to allow the other party to keep their retirement, which has an estimated value of Y, and that those offset each other. Then, flogging a dead horse, you then have a paragraph which identifies the issues that need to be proven so you can determine the evidence that you're going to need to obtain to prove those issues. So there's all of our community property and then the community debt. With separate property, the issue we see the most at trial is going to usually be the house. You know, one party thinks it's separate property, and other party thinks it's community property. And you'll want to make sure that you identify it in the area that you believe it is, and at trial you have to identify why that is. Otherwise, for separate property, you'll just be describing what is separate property and why you think it is such. So for instance, the 1954 pink Cadillac is your separate property because it was inheritance from your Uncle Elvis. You're identifying it and you're saying why it's separate property. That lets the other party know why you think that is separate property for purposes of settlement and for purposes of trial. Now, for the spousal support, if there is an issue of spousal support, you are going to have to do the spousal support declaration. And so all you'll be writing on the brief is a statement to please, that you're asking for either an order of spousal support or termination of spousal support or modification of spousal support. Please see spousal support declaration filed concurrently. If there are no issues because you're seeking to waive and terminate spousal support in a short-term marriage, reserve spousal support in a long-term marriage, or maintain an order that has already been made, just identify that in this area, and you do not need to do the spousal support declaration. And then if there are any other orders you want the judge to make, they would appear at G. The last page deals with the documents that you are going to be doing concurrently with these briefs. Please do not attach the documents. Although you have the ability to do so, attaching the documents basically hides those documents behind your mandatory settlement conference declaration or trial brief, such that they do not appear on our case registry or list of filed documents, and the judge will not be able to identify quickly that all of the necessary documentation has been filed. So we encourage you to please file each of these documents independently so that they will each have their own entry into our case registry and our list of filed documents. You'll then go ahead and date, print, and sign. So that is our settlement conference declaration or trial brief. The next document would be the spousal support declaration. Again, you do not need to do this declaration at all if you have agreed to waive and terminate support in a short-term marriage, reserve support in a long-term marriage, or both of you are willing to accept the existing orders. If that is not the case, you will be required to do it, so let's go ahead and take a look. The next document in the packet is the spousal support declaration, which reviews the Family Code 4320 factors, which are 14 separate statutory factors that the court must evaluate when making a final spousal support order. If you do this online, the captions will be self-populated, as well as your name will appear where it needs to be placed. Now, whether you are trying to do a settlement conference or you're trying to do a trial, you really need to fill this out the same way. And you want to fill this document out as an advocate, which means you want to put your best foot forward. As an example, number 1 is describe the standard of living established during the marriage. Spousal support is not based on a current standard of living. So that if I had won the lottery and was now a millionaire, my ex could not take advantage of that in seeking a spousal support order. The spousal support would be based on the standard of living that was established while we were married. And when we write this, we want to write it so that the facts benefit our position. And as an example, my ex wanted spousal support, so he wanted to show a great standard of living. So he could have written, we were married and lived in a 5-bedroom house in Orange County. We had newer cars and took regular family vacations 2 to 3 times a year. That sounds like a fairly decent standard of living. I, on the other hand, don't want to pay for the spousal support, and I'm going to provide facts that would support a lower standard of living. In my case, I would write, we live in a 75-year-old home in a declining area of Anaheim. The house is in need of major repair. Both of our vehicles have in excess of 150,000 miles on them. And we would regularly take staycations twice a year and vacations with the family every other year. Neither of us are lying. The house is 5 bedrooms. It is in Anaheim. It is 75 years old. The cars are newer, but because of where we work, we put mega miles on it. And we do take staycations and vacations. But you can tell by the way I stated those paragraphs that they're slanted to either getting more spousal support or paying less spousal support. Be your best advocate when you're writing this document. Does each party earn enough money to maintain the standard of living? The reality of the situation is that if both parties worked to maintain the standard of living, when you separate, neither party is going to be able to maintain the standard because it took 2 incomes to get you there. So when you write this, you're going to talk about whether you can maintain the standard based upon the income that is being made and whether the other party can do that. Even if the answer is neither of you can, one of you may be in a much better position to maintain the standard, and that's what you want to discuss. Number 3, does the party receiving support have job skills? Are there jobs available? And what's it going to take to get you back into the workforce? So if you were a stay-at-home parent and you had a professional career before that, you would identify, I was a CPA. While there are CPA jobs available, I have not been in the industry for the past 10 years, and the laws and standards have changed substantially. So I would have to take a refresher course, which would take anywhere between a year and 2 years based upon the needs I have at home and the time I would have available to go to school. So that would be the person who is trying to get the support. And of course, the other person would indicate that they were a CPA for 10 years. There are plenty of CPA jobs out there, and maybe the stay-at-home parent had been taking courses throughout to keep their skills current. That would be identified. Number 4, was the party receiving support unemployed during the marriage in order to devote time to domestic duties? This is fairly straightforward in what it's asking, yes or no. And you might also want to identify, was this the decision of one party or both parties? Did the party receiving support contribute anything to the career of the other party? Did one party work so the other party could go to school? Did one party work in the business for free while the other party built it up to be a mega business? Does the party paying support have the ability to pay support? The answer to that would be yes or no, but you want to explain why. No, I do not have the ability to pay support despite the increased income because I am now taking care of both children primarily on my own and have taken on the mortgage and all the outstanding debt. So that explains why, while you may have the income, you don't have the ability to maintain the standard of living that you may have had. How much money do you need to maintain the same lifestyle? Just put in the information that you think you might need. There's no set number. What are the summary of the assets and debts each party owns, together or separately? If my ex had received a inheritance of $100,000, that would be his separate property inheritance, but it may also impact whether or not he needs spousal support to maintain the standard of living. How long were you married or were in the domestic partnership? If you were married or in a domestic partnership for 10 or more years, you have a long-term marriage, and the presumption is that the court should give you a death or remarriage order. If you were married for under 10 years, you are in a short-term marriage, and the presumption is that you should receive support for half the life of the marriage. Can the party receiving support take a job without significantly interfering with the care of children? What would the child care cost? Again, this is very self-explanatory. What is the age and health of both parties? How old are you? Are you in good health, or do you have health issues that would impact your ability to work outside the home or work at all? Is there any documented history of domestic violence between the parties? This is a consideration given by the court in awarding spousal support. The court generally does not like to have a victim pay the perpetrator, so it is a very large consideration. Are there tax consequences of paying or receiving support? On our present tax laws, the answer is no, but that may change in the future, so please speak with your tax person or your accountant. Will either party suffer harmful consequences if support is granted or denied? Again, very self-explanatory. How does the party receiving support plan on becoming financially sufficient? This is called the Gavron warning. It provides the goal of California that the supported party shall be self-supporting within a reasonable time. If they fail to become self-sufficient within a reasonable time, then they risk termination or reduction of their spousal support order. Does either party have a criminal conviction for domestic violence? That again is a consideration by the court, and anything else you want the court to consider, which may include that the other party is cohabitating and is not required to work to maintain the standard of living as that standard is being provided to them. Or that they did receive an inheritance, or they have a trust fund, or whatever the case may be that you want the court to consider when making a decision as to how much should be paid for spousal support. Then you'll go ahead, date, print, and sign. So anything else that might be needed? Well, supporting documents are not necessary for mandatory settlement conference, but they are necessary for trial. You may want to include documents at your mandatory settlement conference, those documents that I consider to be a smoking gun. For instance, my ex thinks that my retirement earned during the marriage was worth $400,000, when in fact I have documentation that shows that as of the date of separation, it was only worth $100,000. I may want to bring that information into court with me for the settlement conference so that I can show to the other party that their assumptions are incorrect and they may become more reasonable at time of settlement. But for purposes of trial, I'm going to have to bring those documents in, and these documents are going to have to be brought in either by stipulation of the parties, agreement, or you're going to have to subpoena the records and lay a foundation for their introduction into evidence. This would be evidence of the value of any asset or debt, evidence of any income or income producing ability, and evidence to support any position that's disputed in your case. Once you're done with your paperwork, you will complete everything that's appropriate. On the day you're going to have the paperwork mailed, you'll fill out the FL-141 from Part 2 in your disclosure packet. You're going to make 2 copies of everything. You'll have someone 18 or older who's not you mail 1 copy of everything to the other party or their attorney. Have the person who does the mailing fill out the proof of service by mail and file the original 1 copy of everything that you've filled out with the clerk's office. The proof of service is one that you've seen a number of times. It is the FL-335, the one that we have in our self-populating packets. Makes things easy because it already has a list of most of the documents that would be included in a settlement conference, sorry about that, or trial readiness conference hearing. The only thing not listed in this is the joint statement of undisputed facts. The person who does the mailing will identify their address, the documents that are being presented, that they've deposited into the postal service, who they served, their address, the date it was served, where they were standing when they served it, and they will then date, print, and sign. Having completed that, everything will be filed with the court, and you'll be ready for your hearing. That concludes Part 3 of our Mandatory Settlement Conference video series. Please watch our other videos for more information. These include the introduction, what is a Mandatory Settlement Conference? Part 1, the difference between community and separate property. Part 2, completion of the mandatory disclosures. And Part 4, the Trial Readiness Conference documents. If you are able to settle your case at the time of your hearing or before your hearing, or you would like to ask questions or have your paperwork reviewed, please contact the Self-Help Center for assistance. You can contact them at 951-274-4499 or 760-393-2163. Or to make an appointment on your own, you can go to our website at riverside.courts.ca.gov/appointments. You will then select self-help and the nature of the appointment you're seeking. The self-help services through the court are free, but please remember, we are unable to give you legal advice or strategy in our case. Instead, we're here to provide you with an explanation of the forms and the law associated thereto, answer any questions you may have in that regard, and provide a review of your documentation for legal sufficiency. We look forward to helping you in the future. Thank you very much.